You know. Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or alternative dispute resolution, ADR, in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, a postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of Dispute Resolution Mediation Committee. I am delighted to welcome David Hoffman to the EVA show. David teaches courses on collaborative law and mediation at Harvard Law School. He also serves on the faculty of the program on negotiations, Harvard Negotiation Institute, where he teaches the Advanced Mediation Workshop, Mediating Complex Disputes. He is the founder of the Boston Law Collaborative LLC. He once served as the chair of the American Bar Association section of dispute resolution. It is imperative to mention that since 2008, David has taught the mediation course previously handled by the late Professor Frank Sander. Frank Sander is the founder of the Multi-Door Courthouse in America. This multi-door courthouse, MDC, has been replicated in some jurisdictions. David wears too many hats, so I've left the link to his profile below. Thank you so much. Let me stop sharing. For coming on the show the second time, David, I'm so grateful that you agreed to come a second time.
Yeah, I'm very happy to be here, and thank you for the invitation.
Thanks. All right, without wasting much of your time, the first question is, what led to the birth of the American Bar Association section of dispute resolution?
Well, I think the history can be traced back to changes in American law that took place in the late 1940s, 1950s, and 1960s, with the expansion of pretrial discovery. Previously, there wasn't as much of a right to obtain information before a trial, but the courts greatly expanded those discovery rights. And the thought behind that was, let's make trial more efficient, because rather than use the element of surprise, we'll exchange information in advance, and many cases will settle because of that exchange of information. So I don't disagree with that policy. I think it's a very sound policy. What happened, however, was that the cost and time involved in litigation expanded greatly. And that had a number of problems. It crowded the court docket, both at the state and federal level. So that meant people's access to justice was more limited. It also meant that parties with deeper pockets had an advantage, because they could engage in this pretrial discovery, and people who didn't have as much money and couldn't afford lawyers, or couldn't afford, battalions of lawyers, were at a disadvantage. So out of that concern, there developed this American Bar Association committee to a standing committee to focus on what were then called minor disputes, because the thought was, well, we don't need all that apparatus of discovery for smaller stakes disputes, and maybe they would be better resolved with mediation or arbitration, or maybe we should increase the funding for small claims courts. Maybe, and as you know, in 1976, Frank Sander gave a very influential talk at the Pound Conference, saying, let's have a multi-door courthouse, so that the big complicated cases might go to trial, or they might go to mediation. You don't know. The question is, are the parties willing to go some route other than traditional litigation. So
Mm-hmm.
that the Pound Conference, and then shortly thereafter, the creation of this standing committee by the ABA, that was the seed that was planted. And Frank deserves the credit. There were others involved, but he was the one who did that. And that then grew into the ABA section of dispute resolution.
All right. Oh, thank you so very much for that. So as a past chair of the section, what were the major obstacles and challenges faced at the inception of the section?
So I think two major obstacles. The first one was that there were lots and lots of lawyers who had never studied alternative dispute resolution in law school and knew very little about it, because the field was quite new when they received their legal education. And so I remember when I first started getting involved with ADR, one of the questions I would ask at workshops or presentations, I'd ask the audience, please raise your hand if you would feel comfortable explaining to a client the difference between mediation and arbitration. And very few hands went up. In later years, I would say, maybe starting about 20 years ago, 15 years ago, I would ask the same question and many more hands would go up. And I think if I asked the question today in a group of lawyers, probably the majority of hands would go up, but not all the hands.
Yeah.
We still have more education to do. And this is an easy question. This isn't, a complicated ADR question, a very simple question. Mediation is facilitated negotiation. Arbitration is private adjudication. Any lawyer graduating from law school and being admitted to the bar should know at least that much, and I would say more, about the alternatives to courtroom conflict resolution.
Yeah. Oh, wow.
I said there were two obstacles. So one was the lack of knowledge, but the other was the, I think, understandable concern that if we have alternative systems of dispute resolution, one of two things could happen, and they're opposite. But either one would be unfortunate. So one concern was that low-income people would be shunted aside to alternative forms of dispute resolution, and only the well-heeled would have access to the courtroom. And the concern there was because most forms of alternative dispute resolution are private, that the public wouldn't see what's happening in the cases that involve people with the fewest resources. And so they would be consigned to what was called second-class justice. So that was one side of the concern. The other concern was sort of the opposite, which was that if you had enough money, you could hire mediators and you could resolve your cases in private. And so big corporations facing major liability because of misconduct of one kind or another, they could pay an arbitrator or pay a mediator to resolve their case outside of the public view. Now, I would say that ADR is legitimately criticized for creating those possibilities. But I don't think it's really been as grave a problem as some would say. I'll give you one example. There's a lot of controversy about Harvey Weinstein and his sexual misconduct and criminal acts against women. He was able to resolve many of those conflicts privately through negotiation. Now, we don't know the extent to which mediators, if any, were used, but that's an example of a very serious series of crimes being, resolved behind the scenes. Now, of course, he faces public criminal prosecution, but in the private lawsuits, those were hidden from view.
Mm-hmm.
And many of the people who were victimized by Harvey Weinstein and others had signed non-disclosure agreements and also arbitration agreements saying that they would resolve any agreement privately. So there's very legitimate criticism of private dispute resolution in the area where arbitration is mandated before the dispute even arises. So that's been a controversial issue, as you know.
Oh, yeah. Well, thank you so very much. This has been insightful. I wanted to ask about the lawyers' reactions. What was their reactions like?
Well, I think there's a range of reactions. I think there were many lawyers who thought this is having the American Bar Association section of dispute resolution was a way of handling conflicts that really shouldn't be in court. And that's why the first version of the section was about, quote, minor disputes, because the lawyers in the American Bar Association, who tend to be, successful, busy lawyers, many of them from big firms, but not all. We have many, many members who are from small, medium, and even solo firms. But I think many of them thought, well, sure, it's good to have this section because if there's a dispute between neighbors over a fence or a barking dog or some minor dispute, let's get that out of the court. So they welcomed that. But I think there are other lawyers who were concerned that it might threaten the livelihood of lawyers. And looked at what we were doing from a very parochial standpoint. And I'll give you an example of that. So Frank Sander and I were at a meeting of the Massachusetts Bar Association, not the ABA, but the MBA. And we were giving a talk, sort of the basic introductory talk on alternative dispute resolution. I think we were on a panel. I think there may have been one or two others besides Frank.
Sorry, what year was that, sorry?
Well, this is a good question. I would say it was probably in the 1990s.
1990s.
And someone raised their hand with a question, and we said, yes. And he said, I don't get it. He said, I just got my law degree. I just got admitted to the bar. I'm struggling to make a living. And you're telling me that if a case comes along, I should send it to mediation. And I need that case. Why would I send it to mediation? That wouldn't make any sense at all. And Frank and I looked at each other and we sort of smiled because it was like the lawyer who asked that question had not really focused on the fact that he has a fiduciary duty to his clients to handle the case in the best possible way. And if the best possible way is mediation, he has an ethical duty to educate the client about mediation and help the client find their way to mediation if that's what they want. They might not. But at a fundamental level, I think what the lawyer had missed is that the way to build a practice is to serve your clients well. And if you do that, they will tell their friends and neighbors and relatives, and you will be a busy lawyer. But if you focus on how do I enhance my profit as a lawyer, there are some lawyers who do that, unfortunately, and some may be very successful financially, but they're not in compliance with their ethical duties.
It reminds me of Abraham Lincoln, the
right
that he made. All right, thank you so very much. So that leads to the fourth question, which is, with the introduction of the dispute resolution section, what are your assessments of its use, the accessibility to the public, and how would you assess people's reactions and patronage?
So I guess there are two parts I see in that question. I think the section has done a good job of putting out on its website public information about alternative dispute resolution. The adoption of ADR around the United States, and indeed around the world, has been a great success. In that effort, the ABA section of dispute resolution has just been one of many, many, many participants. But having an ABA section of dispute resolution has led to the creation of dispute resolution sections in many of the state bar associations. And I think it was a pioneer, the ABA section was a pioneer, encouraging bar associations in other countries to promote alternative dispute resolution. So in that sense, the United States was an early adopter and a pioneer. However, there are parts of the world where I think ADR has advanced beyond what we've done in the United States. And I want to call out in particular Australia, and especially in the family law area, where the provision of alternative dispute resolution is available through the courts. It's publicly funded. It's completely integrated into their system of family law resolution, and it's considered a primary method of dispute resolution. And then you go to court after you've been through some alternative processes. And so that reminds us of what many people have said, is that ADR, instead of standing for alternative dispute resolution, should stand for appropriate dispute resolution. And litigation should be what you do after all else has failed, rather than thinking of ADR as kind of a sidetrack. Does that make sense?
Yeah, it does. I quite agree with you. And so many scholars on this show, they've pointed out as well, they should be appropriate rather than alternative. All right, thank you very much. So recently the section diversified the composition of its members. What necessitated this, and so far, what are the advantages recorded so far?
Yeah, so one of the things that many people in the ADR movement have noticed is that we have lacked racial diversity, and we have not attracted as many people who serve low-income communities as we should. I think that with regard to gender diversity, we've done better in that area, and the American Bar Association generally has done better. But the ABA, the American Bar Association, has a legacy of racism that it has been working in recent years very hard to overcome. It was not until 1943 that people of color could even become members of the American Bar Association. And that is a shameful history, and something that the ABA is working very hard to overcome. And it's important to overcome it because for ADR to achieve its full potential, it has to reach all communities. And if it's going to reach all communities, it means we have to have practitioners who reflect the diversity of the population here in the United States. And this is a problem that exists around the world.
Thank you so much. So looking at the ABA, what are the notable achievements of the intervention of the dispute resolution section?
Well, I would say one of the biggest was the involvement of the ABA in the Uniform Mediation Act. And there was a parallel drafting committee. So there's one committee of the Uniform Law Commission and an ABA committee, and they worked together to create what I think is a really excellent uniform law. Now, I know that many people who listen to your podcast
Yeah.
are from countries other than the United States.
Yeah.
And so I'm going to pause for a moment just to explain that we have a Uniform Law Commission in the United States. And the purpose of the Uniform Law Commission is to create statutes that the various states can enact. So, for example, with mediation, we have different laws in every state, every one of the 50 states. And in some instances, having different laws from one state to the next is a good idea, because the states are thought of in the legal system as sort of laboratories.
Yeah.
One state tries out, let's say, a mediation statute that says that mediation is absolutely confidential and there are no exceptions. And another state says, well, no, mediation is confidential and privileged, but there should be exceptions for things like child abuse or neglect or planned commission of a crime. Or another state, like Massachusetts, where I live, adopted a mediation statute that says to be a mediator, you have to have at least 30 hours of training in mediation.
Mm-hmm.
All these different experiments are worthwhile. And then the Uniform Law Commission comes along and looks at all the statutes and comes up with uniform law. And then the states can decide whether they want to adopt the uniform law or not. One of the biggest successes of the Uniform Law Commission is the Uniform Commercial Code, the UCC. And that was necessary because business transactions across state lines need to be managed, regulated by uniform law. If you write a check in the state of Massachusetts for goods that you want to purchase in the state of Connecticut or California, you want that check to be handled and honored in the banking system in the same way, regardless of what state it is.
Yeah.
So that's been a great success. The Uniform Mediation Act has been adopted by quite a few states, but not all states yet. But it's a good example of the ABA being in the lead on an effort that I think was very worthwhile.
Thank you so very much. So this is the first time I'm hearing about Uniform Laws Commission and Uniform Mediation Act. So thank you so very much for saying it on this show. So what areas of the section require improvement?
So I think along with the entirety of the ABA, our section should continue to improve in the area of diversity, equity, and inclusion. And also, and this is not a critique of the section, but more a critique of the ABA. There's one resolution that the ABA section of dispute resolution adopted, which did not get passed by the ABA House of Delegates. And it's the resolution supporting the Uniform Collaborative Law Act. So while the section has been very supportive of collaborative law, the section has a committee on collaborative law. It's currently chaired by a lawyer from Washington State named Kevin Scudder. There have been a number of chairs of that committee. I was the chair at one time of that committee. And I think the section has been a pioneer in advocating for greater use of collaborative law. Now, let me pause, because there may be one or two people listening to your podcast who've never heard of collaborative law.
Yeah.
It's very simple, very, very simple. It's a form of conflict resolution where the let's say two parties and two lawyers sign an agreement saying that the lawyers won't take the case to court. The clients, the parties can go to court if they want, but they have to hire new lawyers to do that. And it's a little bit like in the UK, which you're familiar with, where you have solicitors and barristers. The solicitors can handle negotiations, the barristers go to court. So in the collaborative law system, you're hiring a solicitor, but if you need to go to court, you dismiss the solicitor,
Mhm.
but you hire a barrister. So collaborative law is not exactly revolutionary. We've had it in the UK's legal system for many years, but in the
Yeah.
United States, it was considered very controversial. And when the section of dispute resolution, the Uniform Law Commission created this Uniform Act, and the
Yeah.
AB section supported it, the
Mhm.
House of Delegates voted it down. And I think
Oh.
it was the fear, there was fear on the part of the section of litigation
Mhm.
that it would undermine the careers, the professional prospects, the business prospects of the litigators.
Hmm.
Now nobody came out and said that. We can't have collaborative law because
Yeah.
litigators need to make a living.
Yeah.
Nobody was that frank. But I think that was part of the concern, unspoken, and maybe I'm being uncharitable in saying that. But what was spoken by the litigation section is we should not support this because if clients sign a collaborative law participation agreement, they may naively think that this will work out well. And they may
Hmm.
not understand once the negotiation gets started how difficult it's going to be. They may not understand that in agreeing to hire new lawyers, they've handicapped themselves in ways that they couldn't have anticipated because they're not lawyers, they're not professionals.
Hmm.
And that argument carried the day. Right now, the section is thinking about resubmitting to the House of Delegates. Now that the Uniform Collaborative Law Act has been enacted in a majority of American states, it's spreading in Europe, it's and around the world, and Asia, Africa, in Latin America. I am going to be giving a talk about collaborative law in France and where collaborative law is developed. So collaborative law has been a success, and I think
Yeah.
it's embarrassing that the ABA
Yet to
House of
pass.
Delegates hasn't seen the
Approved
light
it.
yet.
Yeah.
I hope they will.
Well, fingers crossed after this they will. And you know, the last time you came on the show, I said I was going to invite you for a collaborative law discussion. I would still want you to come on the show, but I know you're quite busy, so maybe afterwards we would make our time. Give me dates so you can block it. All right, to make sure I get you on the show to talk about collaborative law.
Sure.
All right, so final question is, what recommendation would you give to improve the usefulness and service of the section in the nearest future?
So I think the main frontier that we should be focusing on is bringing alternative dispute resolution techniques and knowledge to low-income communities and more diverse communities all over the United States. And part of that requires creating more support for pro bono systems and also for greater adoption and public funding for alternative dispute resolution in our court systems. Right now, for example, if you go into the district court and small claims court here in Massachusetts,
Yeah.
your case may be referred to mediation. In all likelihood, those mediators are volunteers. And so there's a limited capacity for providing mediation. But if we provided public funding for mediation, as is done in Australia and in other parts of the world, we could greatly expand the reach of alternative dispute resolution to a wider sector of the population. And so I think the American Bar Association can and should make a greater effort to promote public funding of these forms of dispute resolution, not only because it will serve underserved communities, but it will also help our court systems work more efficiently because, I would say the vast majority of cases that are filed in court for civil resolution, as opposed to criminal, focusing on civil, the vast majority would benefit from at least trying mediation. And even in the criminal justice arena, those systems would benefit from more restorative justice mechanisms, which are being used but are not well funded at this point.
All right. Well, thank you so very much. I don't mind, listening to you, but we are running out of time now. So thank you so very much. This has been, of course, a master class, and I truly appreciate you taking our time, to come on the show and educate us, on the achievements of the American Bar Association thus far. And thank you so very much.
I appreciate the invitation, and I really appreciate the service that you're providing
Thank you so much.
in disseminating knowledge about dispute resolution around the world.
Yeah, thank you. I'm following your footsteps. I'm not there yet, but poco a poco. All right, thank you so very much. To my viewers and listeners, thank you so very much for your constant support. Stay tuned for more episodes on achievements on the ABA dispute resolution section thus far. All right.
And before we go, perhaps you should mention that you have a fellowship with the American Bar Association.
Oh,
and this is an honored position that you have received, and you're doing wonderful work there. I look forward to talking with you more in the future about
thank you so very much. And also, I would also want to thank the ABA section of dispute resolution. This shows that they are really inclusive, and for having me and for having others as well, on the fellowship program this year. All right, bye-bye. Thank you. Cheers.